Welcome to Securing Your Brand with SecureMark Legal. On this podcast, we break down the legal side of branding and protecting your business without the legalese. From trademark, copyright, and contracting tips to real-world case studies, we're here to help you safeguard your business, your brand, and reputation. We are here to help entrepreneurs, creatives, and business owners protect what they've built through smart, strategic IP solutions.
Hello, I am Holly McFall, a trademark attorney. Welcome back to Securing Your Brand with SecureMark Legal, where we make legal stuff, especially trademarks, way less scary and way more actionable.
Holly and I work with business owners, creators, entrepreneurs across the country to help them protect their names, their brand, their intellectual property, that which defines their business.
Today, we're talking about what rights you actually have if you are using a brand name without a registered trademark. We'll break down what common law trademark rights are, what they protect, and where the limitations come in.
And I'm Lisa Mosbey, here to ask do I actually have any protection if I didn't register a trademark questions. So ladies, today, what does it mean to have a common law trademark?
A common law trademark is just that, a right that comes from using a name or a brand in commerce. That's never been registered, whether state or federal, you haven't registered that trademark. These rights are created automatically when a business begins using the mark to identify its goods or services. Basically, first to use. The key factor is actual use, not just an idea or an intention. You're actually using that brand name to identify your goods or services.
Yeah, the business must be actively offering the goods or services under that name. So simply reserving a name or planning to use it does not create rights. Common law rights are recognized under state law and can still be enforced in certain situations.
But it's important to remember, you, the business, may not have the ability to stop others from using that brand name without a trademark registration.
And how far do those rights actually extend if you do not have a registered trademark?
Common law rights are typically limited to the geographic area where the brand is actually used. So depending on the circumstance, that could be a city, or a region, or a state. Protection is tied to where customers recognize the brand. So different types of businesses will have different sizes of geographical area that just naturally would be protected under common law rights. Protection does not automatically extend nationwide without federal registration.
Another business will use the same or similar name in a different geographical area. Remember, your state registration doesn't create your right to use a brand name. So someone could be registered for that state in Florida and then have another company in Texas that's using that brand name. If the Texas company registers their federal trademark first and you don't stop them, even if you've been using it longer, it might mean that you're infringing on their trademark depending upon the circumstance. So this potential conflict gets created between the two businesses, and especially becomes important if one of the businesses starts expanding outside of their state. So without federal registration, there's no nationwide priority of use. This creates a potential situation where I can see a lot of infringement occurring.
And then what determines who has rights if two businesses are using similar names?
Well, it's based on first use. It's not necessarily based on who was the first to file unless you didn't object to their filing. That kind of becomes another issue in that regard. The first business to use the mark in commerce generally has superior rights if neither one is trademarked. It's really important, though, to make sure we know who used that business first. You need to have evidential use of that business. You want to save your sales records. You want to save your marketing material. When you registered for your website, when you began selling, maybe invoices, things along those lines, so that you can definitely say, I began using the business on this date. I began using this brand name now. And it gives you priority so long as neither one has got a federal trademark.
Yeah, so that's why documenting early use is important. And it's not something that businesses usually think about. They often think that if they reserved the name with their state corporation office, they have the LLC in the name, they think, okay, I have that date, that's simple, that's when I started using it, that's when my rights begin. So they don't think about keeping these records of when they actually sold goods or services, but it can become very, very important if a dispute arises. it's very important to be able to prove that first use. And that proof comes with these things that we're talking about, these records that you can keep. Many business owners assume that filing creates rights. But again, use often comes first and is more important than when you filed for your LLC or filed your trademark application.
If that company was able to file a trademark application and receive trademark registration, you really may not have a right to go back, and your first use may not matter unless you want to spend the time to do a petition for cancellation, which can be costly, to stop their trademark. Holly, I can think of that food truck. We've talked about this before on our podcast and how sad that story is. We call it our most horror story that we have in trademark law. And to kind of give a short version of it is that there was a mom and pop that started a food truck, and their food truck only sold dessert. That's all the food truck sold. And it was small. It went around, think like high school football games, weekends at the beach kind of food truck. It wasn't, they didn't intend to franchise. It was their side gig. So they registered with the state, they created their LLC, and they thought they were good. They were protected. They even had a website, if I remember correctly, that you could locate the food truck so you know where it was, which beach or which football game it was at. And someone left a positive Google review, not negative, positive, saying you need to bring this dessert from the food truck located here to your restaurant in another state. And they filed a cease and desist, and they filed an injunction, and they shut down the business of the small food truck because they had registered the trademark. Now, they hadn't been in business longer. So, the priority should have come into play, but they had a valid trademark registration. They can nationwide priority. They have nationwide use. They could stop the small mom and pop food truck. And they were also small. It was costly to file a cancellation. They had to go through rebrand and the rest of it. Unfortunately, in their case, they lost their food truck. They couldn't afford to redo all of that. So, though common law is important and priority is important, trademark registration is really what gets you ownership of that brand.
And what are some common misunderstandings business owners have about trademark rights? I mean, that's a prime example. Are there others?
Yeah, I really think that thinking that because they have the LLC means they have the trademark is probably one of the most common that I hear. I really do, because that's such an official thing. When you file for your LLC, it feels really important, and it is in other ways, but it's really not relevant to your brand name. Your LLC name can be a completely different name than the brand name that you use outward facing to the public, and that outward facing name is your trademark. So I think because that is such a formal process that you go through, and you often consult with your accountant, and it's a big deal, people think that because they have that name that they own the trademark rights, and that's just absolutely not the case. Again, same thing with registering a domain name, your website address. That's really the same thing. Just because you were able to get that www in your name doesn't mean that you own the trademark to it. Social media handles, very similarly, does not automatically mean trademark protection. Those are really the biggest ones that I see.
Yeah, a lot of these steps that we see, someone will come to us and say, no, I own my brand, I own my company. And we're like, you own the company, we're not sure that you own the brand yet. And that's where this misunderstanding can lead to confusion and costly mistakes. Federal trademark is the only way to make sure that you fully own those brand identifiers.
And what happens if you have been using a name, but someone else files and registers it?
So just like the food truck, if it's registered first and you can't go through the process of canceling, it can be costly to do that cancellation process. So it's not a be all and end all. If, we've seen the situation where a competitor, sneakily will file for their competitor's brand name and see if they can claim it, or their slogan even, to see if they can claim it. And if it's recognized early enough, if it's watched and found early enough, you can file an opposition to those trademarks. You can say that we have prior use. We've been using it longer than you. We can, have those rights of priority of use. So it becomes more like a shield than like a sword in those cases. But you need to make sure that you file the opposition timely. A publication is only for 30 days, and that you go through that whole process. It may be a challenge to fight a company that's registered that trademark or that slogan. And like I've said, it gets costly quickly. So registering your trademark early is the easiest way to make sure that you can protect your brand name.
Mhm. And when you start getting into these things like opposing pending applications, seeking cancellation of registered marks, you're entering into potentially litigation territory. You can open yourself up to discovery. Discovery is the process in litigation where each side requests information and documents from one another, and that can become quite costly quite quickly. If you don't have your registered trademark, you have to prove that you own the brand. Anything you do in litigation is expensive. So all of these additional steps just mean more and more money. It's simpler when you're in the trademark application process and opposing it early on with the examiner, as opposed to filing a cancellation and being in litigation. So again, timing matters very much. There are deadlines that when you have to take action in all of these different types of proceedings. And if you miss the deadlines, you could be out of luck. And again, we cannot stress enough how important a comprehensive search is before you file your application, and making sure you file your trademark registration early. Federal registration gives you nationwide priority and stronger enforcement rights. Waiting to register increases the risk that someone else files first. So even with prior use, the process can become more complicated and costly.
That makes sense. Before we wrap up, what are a few key takeaways for business owners thinking about trademark protection?
You can trademark a name even if it's not in use. So you can go ahead and file a trademark application with an intent to use. So when you're just starting out your business or before you launch a new product, you can file an intent to use application. Really get ahead of the game. Make sure you can own that product or business name. But if you're already in business, filing your trademark application as soon as possible, using that mark in commerce and making sure that you have proof of that use in commerce. You want to make sure that you're not just limiting your rights geographically. You're making sure the name can be owned nationwide. It's not just generic or geographical. Making sure that the LLC names, the domains, and social media is an understanding that that does not create rights. It doesn't create trademark rights to own those. Maybe priority, but not trademark rights. And like I said, a registration federally is the strongest protection you can get nationwide.
Understanding these differences early can help businesses avoid costly conflicts as they grow.
And that's succinct. That makes total sense to me. I want to thank you for joining us on Securing Your Brand with SecureMark Legal.
And if you're starting a business or have been in business for years, registering your trademark and protecting that which you have worked so hard to build. You can learn more at SecureMarkLegal.com.
A great business is built on a strong foundation, and that is what trademark registration provides for your business.
Thanks for watching. Be sure to hit that like and subscribe button and leave us a review in the comments.